investment. Well, ladies and gentlemen, before we go to the National Land Code, just for a start, Malaysia, for information, the right to property is entrenched in our federal constitution under Article 13. So it means that everyone have a right to own a property, and no property can be taken away without proper compensation. That's why when you do land acquisition, compulsory acquisition by the government and whatnot, they will always attempt to compensate you. This is entrenched in our article. Just for your information, this also applies to foreigners. It means that it's possible for foreigners to buy subject to certain approval. And for that, I want to compliment Malaysia being the most unique in the whole of Southeast Asia region. We are perhaps the only country that allow, right, direct foreign ownership, right? And other than Singapore, but Singapore they also limited as to category, and also location. Like Sentosa, you can actually buy landed, kind of thing. But in Malaysia, generally it's possible, just that you have to observe certain procedure. Now, other than federal constitution to tell you that you have the right to own a property, then they want to know that what type of title is conferred against you. Now, just for your information, very key point. Land is a state matter in Malaysia. Land is a state matter in Malaysia, right? The federal is only doing all the mechanism to regulate the policies and whatnot, so that we have the same system applied throughout all the states. That's why sometimes when you buy or you invest in property, there's a need for state authority consent and whatnot, because land is strictly a state matter. Okay? So we have the National Land Code passed by the federal government to make sure that there's consistency as to what we are applying in terms of the land processes and whatnot. That's why you have a lot of standards formed under the Land Code. Now let's look at Section 340 that talk about indefeasibility of title. Now, if you look at the word, it said the title or interest of any person or body for the time being registered as proprietor of any land and in whose name any lease, charge, or easement is for the time being registered. It means that if it's appeared on the register at that time, alright, shall subject to the following provision of these sections be indefeasible. Okay? In simple terms, it means that if your name appear on the land register as the owner, as the chargee, as the leaseholder, or the easement holder, it's all unchallengeable on prima facie. Right? He said subject to the following provision. So let's see what are those provisions that actually can alter. Now, the title or interest of any such person or body shall not be indefeasible. So it means that if you have a title of trade, it can be challenged. In any case of fraud, misrepresentations to which the person or body or any agent or any person or body was partly or privy, or where registration was obtained by forgery and by means of insufficient or void instrument, or where the title or interest was unlawfully acquired by person or body purported to exercise any power or authority conferred by this law. So what this simplified, very simple. If there's a fraud involved, forgery involved, some illegality involved, then this question of indefeasible title can be challenged, right? So other than that, normal circumstances, not a problem, all right? Now let's look at another interesting section. This is section 340 sub 3. Now this is like a flow to just now the provision and number 2. So basically what it is saying is that when the title or interest of any person is defeasible by virtue of the circumstances I just highlighted, i.e. the forgery, the fraudulent transactions, the illegality that we talk about, voidable instrument means that you're not entitled to it in the first place but you pass it on, then it shall be liable to be set aside in the hand of any person to whom it may subsequently transfer. Let me just highlight to you at this point, what does this mean? Whom it may subsequently transfer. Just remember this because we're going to talk about this. Now, any interest subsequently granted there shall be liable to be set aside and for the time being vested. And this is the proviso. Proviso means that unless, what happened? It means that it said here, provided that nothing in this subsection shall affect any title or interest acquired by any purchaser in good faith or for valuable consideration. So two things. If you bought it by good faith, number one, means that you have checked everything, everything's proper, there's no hanky-panky involved, that's one. Number two is that for valuable consideration, so above market price and all that, you actually check, right? Then by any person claiming through such purchaser as well. So two things. two things, there's an exception, good faith, alright? And there is valuable consideration. So if I sum up these three sections for you, section 340 basically says this. 341 said, if your name appear on the register as an owner, then your ownership shall not be challenged. Okay? Save for what is stated in number 2. Number 2 said that if there's any forgery, misrepresentation, any illegality, or anything that's challengeable in that sense, then your title is challengeable. Okay? Then what happens is these three, and they give another proviso on that, they said, although it is challengeable on that sense, but if you can prove that you are buying it in good faith, and if you can prove that it's for valuable considerations, alright,